All right, boys and girls, welcome back to another edition of Freedom Steel. Todd Vandermeide, former NRA contract lobbyist and Illinois gun law guru. Today what we're going to be talking about is this case filed in Naperville. This is the case about Naperville passing an ordinance banning the sale of magazine-fed semi-automatic rifles and some other pistols and stuff. And so we fought about this over the summer. The city council passed it as their virtue signaling that they were doing something, and got into a briefing schedule, and so the briefs have been submitted. The village is getting pro bono legal work from Perkins Coy, I guess. Somebody said they've got some connection to Hillary. But anyways, they've done pro bono work. They were involved in the Naperville, or the Highland Park fight in Friedman years ago. I have read this brief. I've gone through it and I've highlighted some stuff. So I'm going to be scrolling through this brief, and we'll put it off to the side here. I like you to actually see what they are saying so we can talk about the arguments. But I'm going to be honest with you. I'm not sure one whiskey is going to be enough for me to get through this thing. This video could run long, and if it does, then we'll break it up into a couple of parts just to keep the time down on it. So with that, it's 28 pages in total, about 20 pages of briefing with a little bit of dead space, but this tells us where the anti-gunners are going. This lays out the playbook, their deceitfulness, and they're trying to rewrite Heller and the test in New York. They keep calling it Bruin. I have a habit of calling it New York because New York State Rifle and Pistol Association should get credit for this. But anyways, so let's get right down into this thing. Here at the opening of their brief, first, the Second Amendment's plain text does not cover Naperville's ban on the sale of certain assault rifles within city limits. Second, Naperville's ordinance is consistent with this nation's historical tradition of regulating firearms, including the wide latitude afforded governments to restrict dangerous weapons. All right, we're throwing the BS flag right off the get here because we know that the Second Amendment's plain text to keep and bear arms. How do you keep arms if you cannot acquire arms? Acquiring arms means you have to get them from some place. So let's see what else we've got here. Like I said, I'm going to scroll through a bunch of this. You can go back and read the brief. I'll try to post it on Facebook or somewhere else as a PDF, and therefore let you guys read the whole thing. I suggest you have something of an alcoholic beverage to drink when you're doing this, because it's going to make your head hurt, some of the stuff they do. Plaintiff's claims fail because the ordinance does not burden conduct protected by the plain text of the Second Amendment. Naperville's ordinance is a limited restriction on the commercial sale of one type of weapon. It is not a blanket ban on sales of firearms, let alone a ban on possession and ownership of assault weapons. The plain text of the Second Amendment says nothing about the sale of arms, only their use. Beyond this, the Second Amendment protects only those arms which are in common use for lawful self-defense, and the plaintiffs have offered no evidence that assault rifles are used in such manner. This is the same bullpucky that the AG's office in Maryland tried to throw up at the Fourth Circuit last month. They're trying to bootstrap a couple of things. That not only is it in common use, that they are possessed and used under the term keep. Keep. That's all you have to do. You have to keep these things to make them in common use. And they're trying to bootstrap that you have to not only have them, but they're actually used in cases of self-defense. They're probably going to say has to pull the trigger, much less brandish or anything else. Finally, before or after brewing, no court is held. Prohibiting the commercial sale of assault rifles violates the Second Amendment. The ordinance is constitutional on its face. Be effing beep. No. You guys must, you know what you've done? You've just gone full retard. There is no other thing. Illinois Association of Firearms Retailers. Here's this brief, and let's read what they say. This was the 7th Circuit, the very circuit that the suit in Naperville has been filed on the ban of gun sales and transfers. Prevents Chicagoans from fulfilling within the limits of Chicago the most fundamental prerequisite of the legal gun ownership, that of simple acquisition. Judge went on. Indeed, this reasoning makes sense because if all cities and municipalities can prohibit gun sales and transfers within their own borders, then all gun sales and transfers may be banned across a wide swath of the country if this principle is carried forward to its natural conclusion. So they talk about Azell, where the argument in Azell was, well, they can go outside the city for their range training. Well, so here too, the fact that Chicagoans may travel outside the city to acquire a firearm does not bear on the validity of the ordinance inside the city. Infringements of this right cannot be compensated by damages. In other words, the measure of irreparable harm in Ezell was the weight of the burden the ordinance placed on the core Second Amendment right, which is precisely the very issue now. This means that Ezell's requirement that the Second Amendment be exercisable within a specific geographic unit is not combined to the specifics of Ezell's procedural posture, and under MCC 8-20-100, any new would-be gun owners cannot exercise their right to acquire a gun for self-defense within Chicago itself. This is a serious burden on that right. There you have it, ladies and gentlemen. They just flat out lied here in this part where no court has held prohibiting the commercial sale of assault rifles. They may be trying to parse words here that it's only about assault rifles, but commercial sales of firearms and their prohibitions have been ruled on by this district. They didn't say it was only assault rifles. Chicago had a broad blanket ban, and we'll get into some other stuff. Conducted a textual analysis and expressly held that the plain language of the Second Amendment only covers ownership and possession of handguns for self-defense. BS. Again, man, that's not what Heller said. We've gone over this time and time again. Heller talked about lawful uses, such as self-defense within the home. Not only self-defense within the home, and not only handguns. Because Heller clearly talked about, some have made the argument bordering on the frivolous that only those arms in existence in the 18th century are protected. We do not view constitutional rights that way. I don't know. These guys keep trying, this lawyer ought to be sanctioned for the lies he is putting forward in the way he is twisting and misconstruing what these cases have said. Going on here, the Heller court determined that the Second Amendment only protects an individual's right to keep and bear arms. Parsing the plain text of the Second Amendment, the court noted that one, the phrase keep arms means to have and possess arms, and bear arms simply means to carry, or to wear, bear, or carry. What is it, dude? Ezell and Illinois firearm retailers clearly show that training, acquisition, and sales are covered under the Second Amendment. Are you just that dense in all this stuff? Nothing, in our opinion, should be taken to cast doubt on laws imposing conditions and qualifications on the commercial sales of arms. They're going to try to drive a bus through this part of Heller, but that's not what you're talking about. You're not talking about conditions and qualifications. Could a background check be required at a commercial establishment for the retail sale of a firearm? I believe that's what they're talking about here. Are they saying that there could be an age limit of 18 years old in order to buy a firearm at a commercial establishment? Yes, it's probably what they're talking about here. Hasn't been completely flushed out, but they're going to try to drive a bus through this, and they're just wrong. Textual elements of the Second Amendment cover the individual right to possess and carry weapons, and said nothing about the right to possess or sell assault rifles. Emphasis added, yeah. The Supreme Court has thus determined twice that the plain text of the Second Amendment only protects the right to keep and bear handguns. No, it did not. It did not. Heller didn't say that. McDonald didn't say that. And, you forgot about Quintero, where the right extends to stun guns, and now you've ignored New York and what it said. Federal courts of appeals have consistently held that the Second Amendment does not even protect the right to possess assault weapons, let alone sell them. Friedman v. Highland Park. Here you go. You guys are dredging up all this dead letter law. The law, Friedman, is dead letter law. It has been castigated to the dust bin of history. It is useless. They used intermediate scrutiny. They used interest balancing. They said that firearms that in 1791 were only single shot, and therefore they completely ignored Heller's findings and what Heller was about. So no. You cite Wilson v. Cook County. Yes, Wilson was found to intermediate scrutiny and much the same. But it's dead letter law in light of New York. Plaintiff's arguments that these cases cited above are abrogated by Bruin misses the mark. These cases did not rely on means and tests foreclosed by Bruin. Instead, they relied on an analytical framework established by Heller. They did not. They did not. They sat there and they used an interest balance. Intermediate scrutiny. It's out. It was cited 4 times in Friedman. It's out. This is another bald-faced misrepresentation of what that law, what those decisions said. We have found no authority that remotely suggests that at the time of its ratification, the Second Amendment was understood to protect an individual's right to sell firearms. You've got the inverse of the test. The test is whether or not there were regulations or laws that restricted the ability to sell firearms. It's not on our side to find something that says, here it says that it was okay to sell guns. No, it's on you to show the activity was regulated. The burden is on Naperville, not our side. Noting that the courts have held that the sales of firearms are not protected by the Second. Again, that's BS. This time they just said the sale of firearms, period, the end. Then please tell me, what was Illinois firearms retailers all about if it was not about commercial sales of firearms? Do you guys not have LexisNexis at your law firm? Plaintiffs have not proven assault weapons under the ordinance are in common use for self-defense. Here again, they are trying to bootstrap that argument that they have to be used in self-defense. It's a bogus argument. It was first fronted a while ago at the Fourth Circuit with Maryland, when those arms are not commonly used for self-defense. No, that is not the test. That is the highest test, that if guns are used in self-defense, but that is not the test. According to the plain terms of the Supreme Court's Second Amendment precedents, the test for the Second Amendment's protection of a particular weapon is common use, not common ownership. BS. Quintero says ownership is good enough. 200,000 stun guns was good enough to make stun guns in common use. Assault weapons like those implicated by the ordinance are most useful in military service and are unsuited, uncommon for self-defense purposes. See Colby v. Hogan. That was the original Maryland semi-auto ban. It is now dead letter law because Colby has been superseded based on its test and its reasoning by New York. And you want to take a survey of all the guys I run with? ARs are kept and maintained for self-defense. I know guys that keep a truck gun. I know guys that keep them in their bedroom or up against the back wall or something for self-defense. Tellingly, plaintiffs point to no evidence such as a survey data or studies showing that assault rifles are frequently in self-defense or have ever been needed to engage in effective self-defense. Plaintiffs instead argue that firearms subject to the ordinance are in common use because of their popularity, quoting statistics of a number of these firearms sold in recent years. That's all we have to do. We don't have to prove squat. You have to prove the other side. The burden of proof is on the government, not our side. And yeah, they are in common use. So says Catano. But common ownership is not enough. The phrase in common use, as used in Heller and McDonald, does not simply refer to a weapon's prevalence in society or the quantities manufactured or sold. See Colby. Again, you're using dead letter law. You keep trying to bootstrap this stuff up, but the fact is Catano is controlling in this case. Stun guns, 200,000, Massachusetts. You guys, they won't want to recognize this. Well, let's see, because commonality depends in part on what the law allows. Friedman, for example, machine guns were all too common during Prohibition, but that did not immunize, I got tongue-tied, them from heavy regulation and an eventual ban on the grounds there are military-grade weapons. That was all decided pre-Heller. And the Miller case from 1930 whatever, Miller didn't even show up, and that was dealing with sawed-off shotguns. So we will get to a challenge and a test of the NFA, but again, you're trying to conflate machine guns with modern semi-automatic rifles. They keep trying to bootstrap every gun control play, every phraseology, everything they're trying to do. And it's just a load of BS. Courts instead must consider the suitability of the weapon and the actual use of the weapon for lawful self-defense. Duncan v. Bonta. That's the Ninth Circuit. And I believe that since the Ninth Circuit Court of Appeals backed up Benitez in his district court ruling, this was the en banc opinion. The en banc opinion was rejected by the Supreme Court, was vacated, and remanded back to the lower court. And it now sits back in Judge Benitez's courtroom. So again, you're citing a decision that's been vacated by the Supreme Court, no less. Let's see. Plaintiffs provide no evidence to the court to conclude assault rifles are in common use for lawful individual self-defense. Self-defense is not the matrix. Under Heller, the holding was for lawful purposes such as self-defense. You seem to ignore that such as. All the anti-gunners do. They don't like that. On the other hand, evidence exists that assault weapons, including those contemplated by the ordinance, are used to commit mass murder all too often. Yeah, this is interest balancing. This is interest balancing all over again. That's all you're trying to do here is show interest balancing. And you didn't list a couple of shootings here where they used pistols only. Way to skew the data, counselor. Let's see. Oh, here we go. Church shooting pistol. Yeah, Glock. Yeah, I think they're still missing a couple here. I think they are. All right, boys and girls, we've hit the 20-minute mark on this video, so I'm going to have to break it up into two pieces because it looks like it could go 40 minutes total. So, again, hey, hit the likes, the subscribe button, copy, paste the link, share it around to all the social media sites you got, Facebook, Instagram, whatever, and let your friends know about the channel, and I'll get part 2 edited up here pretty quick so we can finish out the discussions on this brief that was filed by the city of Naperville to protect their ordinance on banning the sale of semi-automatic rifles. With that, frag out.